Oh man, this poor judge isn't being paid enough to have to deal with this. Judicial misconduct at its finest. They put him in another courtroom? Hi there, Matt Clark again from Cohn Clark. Today I'm going to react to some clips from Darrell Brooks representing himself in court.
If you are allowed to represent yourself in this case, sir, you will not have attorneys assisting you. If I let them withdraw, they're gone from this case. Do you understand that?
I think I will probably be better served representing myself.
Yeah, no. Never better served representing yourself. This is how I know this to be true, okay? No lawyer, at least no lawyer that knows what they're doing and is experienced, would ever go into court and represent themselves, right? And a lawyer has been through 4 years of undergraduate education, 3 years of law school, passed a bar. Most lawyers, by the way, who have passed the bar and come practice law are not prepared to walk into a courtroom and try a case. That takes several more years of apprenticeship before you get to that point. So no lawyer in their right mind would go represent themselves in court, and certainly no lawyer in their right mind would believe them to be better served by representing themselves in court.
You had torn ligaments?
Objection leading.
Overruled.
You say that in the question before?
Sí.
Yes.
And were those both in the same leg?
Objection leading.
Sí.
Sorry,
Yes.
overruled.
Wow. So, you know, in one of my prior videos like this, we talked about what a leading question is. Let me just talk about it one more time. When you call a witness, okay, so if that's your witness, which Darrell Brooks, at least if I understand this correctly, called this person as a witness in his defense, okay, if you do that, you can't ask your own witness a leading question. A leading question, of course, is a question where in the question itself, the answer is implied, such as, isn't it true that you were wearing red on the day of the incident, right? It implies to the witness that they were wearing red, and they can simply answer the question with a yes or no. On direct examination, if that's your witness, you can't do that. However, on cross-examination, that appears to me to be what is happening here. You've got the district attorney cross-examining the defense witness. The district attorney is absolutely allowed to ask leading questions.
If we
Of course.
just wait when there's an objection. I'm overruling it. It's relevant. It's not leading. The witness's answers may stand.
I mean, yeah, you overrule every objection.
And the jury will disregard the additional commentary made by Mr. Brooks at this time.
Judicial misconduct at its finest.
Judicial misconduct at its finest. You know, it would take an incredibly patient judge to deal with this. Most lawyers have been in a courtroom when there is a individual who is representing themselves, what we call pro per, okay? Pro per just means that they don't have a lawyer, they're representing themselves. Again, something that's never recommended, but sometimes, especially in civil cases, you know, there isn't actually a lawyer for every case. Some cases you just can't find a lawyer to represent you, and so you decide to take it on yourself. Judges are generally very patient with a pro per litigant, right? Mr. Brooks, in this case, of course, is pro per. To have an entire trial like that and the judge just having to deal with all of these little extra comments and instruct the jury to disregard these comments would be unbelievably tedious. It would get old. The judge has a tremendous amount of patience to deal with it.
So why have I been held in contempt?
I didn't hold you in contempt, sir. You are simply in a different courtroom based upon your disruptive behavior. I'm giving you the opportunity.
Has not been disruptive.
I've put my findings on the record, sir, and the record stands in that regard. I'm giving you the opportunity, if you can,
Oh man, this poor judge isn't being
indicate
paid
to
enough
this
to have to
court
deal
that you
with
will
this.
conduct yourself with courtesy and decorum. Are you willing to do that, sir?
Is Your Honor willing to tell me why I've been held in contempt?
Well, there's of course the law, right, which would be everything from the Constitution on down to case law, right? And then, of course, we have rules of civility and decorum, okay? Like just as an example, okay? If I'm in federal court, right? In federal court, there are very specific rules as to where you can even stand within that courtroom. In most courtrooms, you're not even allowed to make what we call speaking objections, all right? You can only make an objection. Is the question leading? Is it irrelevant? Does it lack foundation? Call for speculation? Is the question vague? You're allowed to say those things, but you're not allowed to say the next part, which is, Your Honor, the question calls for speculation because... You don't get to explain it. Most judges don't want you to do that because that's a way that a lawyer kind of wiggles in things in front of a jury that they shouldn't really be telling the jury. So most judges will say, make your objection. If we need to argue over the objection, we'll either dismiss the jury from the courtroom or we'll go and have a sidebar, which you see in a lot of cases.
We are back on the record. Appearances are as they were before. I need to make a record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. On every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility.
Yeah, so a good example of showing disrespect to the court, not following court rules, taking your shirt off in the courtroom. Bad idea.
I heard a horn beeping, and then a Ford Escape came through the parade route, and you drove past me and wouldn't stop, and you continued driving into the parade route.
Who is you?
Darrell Brooks, the defendant, seated at the table.
Let the record reflect that I do not identify by that name, nor do I know anybody by that name.
Your objection is no.
I don't even know what to say about that, right? The detective on the witness stand identifies the defendant as the guy driving the car that drove through the parade route, visually identifies him in the courtroom, and then by name, and Mr. Brooks then offers, I guess, some self-serving testimony that he does not know anybody by that name. I don't know that I understand that.
I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known.
I just watching, and I'm sure that was just a brief clip of what was a much longer closing argument by the prosecution. That's a really compelling closing argument, right? I mean, her argument is that Mr. Brooks committed murder here. This was no accident, right? The only way you could accidentally run over 6 people and kill them is if you passed out at the wheel, right? If you had a heart attack or a stroke or a seizure, right? That would be the only instances that I can come up with where that would be accidental, right? Still could be considered manslaughter, may not be considered murder under those circumstances. But here, based on what I'm listening to and what I've seen of this trial, you have an actual conscious decision to drive into a crowd and run people over, and the prosecutor was doing her best to convince a jury of that.
Instruct the jury to come out. For the record, the written decision is once again being provided to the
I accept
defendant.
for value and return for value this document, as it is not based in lawful.
I accept for value and return for value this document. I don't even know what that means, right? It strikes me as Darrell Brooks is getting some advice maybe from I don't know. I don't know what this gentleman's background is, but he's getting some advice from maybe someone in prison, because a lot of this is just like random legalese mumbo jumbo that really doesn't have any meaning in the context of his case. And it's like, if you look at the way that he addresses the judge, he'll look down at a notepad and he kind of reads something off, and then he looks back up at the judge. It's almost as though somebody has just given him snippets of like things that sound legally authoritative to say in the courtroom, but really don't have any application in his case. And so it's almost as though somebody's handed him these statements and he's just randomly spouting them off. Again, I just can't imagine how frustrating that had to be to sit through for the judge and the jury and, you know, the family members of these victims who are clearly, I mean, I can see in this image, are sitting in the courtroom. It must just be endlessly frustrating.
And it does not prove subject matter jurisdiction whatsoever. Refers to some complaint that was filed in the name of a trust, not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you aware of that?
Please be prepared with your closing argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have?
I think that it's important to point out in this, right? And this is something that lawyers see all the time when we're in a courtroom if there's a pro per litigant in the courtroom, right? Of somebody representing themselves. The judge can't give legal advice, right? The judge is not allowed to give either party legal advice. So it's not like, even though Mr. Brooks is not a trained attorney, it's not like the judge can hold his hand and give him legal advice throughout the case. It doesn't work like that. And I think that that's something, I've seen that myself when I've been in a courtroom where there's a pro per litigant and they keep asking the judge legal questions, right? They're looking for legal advice. The judge isn't allowed to give them legal advice, right? The judge is the neutral in that courtroom. They're not allowed to advise either party.
That. And
Were
I'm
they
advising
informed?
you one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
they
Brooks,
are-
you
that
have
they
no
have
right
the
to
power.
make that argument to the jury.
It's true. They have the power.
All right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury.
I mean, if you're on this jury, you've got to be at a point where you're just pulling your hair out. You know, you want to get back to you want to do your civil duty. You want to do your duty under the law, but it's like all of this time wasting and yeah, it would be endlessly frustrating to sit on a jury like that. Let me tell you something. Juries take that out on the litigant who they believe is wasting their time, right? Juries are not kind to a
Thank you.
litigant
Please be
who they
seated.
believe is wasting their time.
Mr. Brooks, you do not have a right to request jury nullification directly from this jury. I direct your attention to the Bjerkas case, Bjerkass, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able
Yeah, I mean, the fact that he's mentioning nullification in the presence of the jury is arguably grounds for a mistrial right there. And, you know, now, if I'm this judge, the last thing I'd want to do under the circumstances is grant a mistrial, because that means I got to try this whole thing over again. But the prosecution, they could have stood up and asked for a mistrial. I think it would have put the judge in a tough spot. I think what this demonstrates is being a judge is a hard job. It's the hours are long. I mean, you think that the judge is only working while they're on the bench. Wrong. I mean, they're working before and after and into the evenings and on the weekends. I mean, I see our local judges at times downtown having lunch on a weekend because they're in their courtroom getting ready for the next week, right? It is hard work. And here's another thing that I think that this really, I hope people recognize is the amount of our taxpayer dollars that get poured into this, okay? And we have to remember the way our judicial system is set up, right? Our system is set up not to convict the guilty. Our system is set up to protect the innocent at all costs, right? And so all of these various roadblocks and things that come up along the way with a case is to do our very best as a justice system to prevent wrongfully convicting somebody who is innocent, okay? And so we've got all these things in place to try to do that. And look, I'm not going to pretend that there aren't instances where somebody who is innocent is wrongly convicted. We know that happens, right? But it happens an infinitesimally small percentage of time in the greater scheme of the justice system. And the amount of energy and taxpayer dollars and resources that get poured into our system to try to ensure that we are protecting the innocent. I think that this is a good example, right? This judge's patience is really a good example of trying to protect what could be somebody who's innocent.
Regarding the issue of jury nullification,
It's
that
not
is
defiance.
requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the
vehemently-
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record.
Yeah, so when you make an objection on the record, you can just make your objection. You don't have to make it over and over again. It doesn't make it stronger the more times you make it. Also, by putting the word vehemently in front of your objection, it's not strengthening your objection. Actually, if anything, it's kind of weakening your objection. Like those superlatives are unnecessary. Just again, something that a real lawyer wouldn't do.
But
May
my
I ask
rule
for legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling.
Your
For the record, may I request a legal or factual basis for your ruling?
And
Not one pertaining
he's
to-
still looking down at like this play. You know what this reminds me of? I'm just gonna throw this out here. Like the way he looks down and he just spouts off this legal mumbo jumbo that doesn't apply. It reminds me a little bit of watching an NFL game when they cut to the coach on the sideline and he's got like the laminated sheet. There's like different colors and it's in like a 2-point font, right? And he's got every playbook or every play in their offense and defense is on that thing. That's what it reminds me of. Is he's got one of those and he's just going this one or this one or this one.
The verdicts read in open court, are those your true verdicts?
It is.
Thank you. Juror number 14. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number
So
9.
what you have going on here, after a jury renders a verdict, the parties have the right to ask for a poll of the jury. It's just a way to confirm that the jury's verdict as reported in open court is accurate. So a judge will usually go through and ask each juror individually if the verdict as read accurately reflects their verdict and their decision in the case. And that's what the judge is doing. And here you've got Darrell Brooks staring each of them down, each juror down, as the judge goes through and polls them. I mean, I guess you could argue it's some effort to intimidate. I don't know. I mean, you'd have to assume at that point that Mr. Brooks is consciously deciding what he's doing in this courtroom. I mean, some of this stuff looks like pure reactionary. You know, it's pure id. There's no nothing else going on. Not what you would consider to be normal conduct in a courtroom. In some, right? I think what we've seen here is this is a great example of why not to represent yourself. I think the conclusion of the case tells you as much. He was convicted, okay? But there's really no circumstance where I would recommend to someone that they walk into a courtroom and they represent themselves. There is competent counsel available to you, either counsel you can pay for, or as we all know from the Miranda rights, if you can't afford an attorney will be appointed for you, okay? Thank you all for watching. If you have something you'd like to see us react to in the future, put it in the comments below, and please click the link and subscribe to our YouTube channel.